this is Keith Davidson at Albertson and Davidson. In this video, I want to talk about freezing trust assets. So everybody at the beginning of their trust lawsuit wants to know, aren't the assets of the trust locked down or frozen while the lawsuit is ongoing? And the answer is no, not at all. That's not how this works. And it can be very surprising to people to find that out. So there's a couple of different ways to go about trying to freeze trust assets while the lawsuit is pending, but they're not always that easy to actually secure from the court because you have to get a lot of this stuff from the court and from the judge. The easiest thing to lock down is real estate because once you have a lawsuit pending, you can file what we call lis pendens, that's a litigation lien, against the real property. But there's a caveat to that. Your claim must have some aspect to it that will affect the title or possession of real property in the future if you're successful. If you don't have one of those types of claims, then you cannot file a lis pendens. Well, you can file it, but the other side's going to file a motion and ask the judge to remove it. And if they're successful in that motion, then you'll have to pay their cost once it's granted. So you want to be a little careful about filing lis pendens and make sure you have a good basis for filing it. But if you do, that's one way that you can lock down real property. Once the lis pendens is filed, in theory, it can't be sold or refinanced without the lis pendens coming off. Now let's talk about banks, brokerage firms, liquid assets, things that aren't real property. Those are a lot harder to lock down. And what you have to do is go to court on a temporary restraining order and a preliminary injunction. And what you're asking the court to do is to put a freeze on the assets pending the lawsuit. The problem is there's a certain standard you must meet to get that type of relief because we call it pretrial relief. So nothing's been tried yet. No evidence has been presented yet. So you literally are asking the judge to shoot from the hip. And while you might think it's fair to freeze the assets while the lawsuit's ongoing, the law doesn't see it that way. And so what the law requires is you must show that there's some sort of irreparable harm that's going to befall the trust if the assets aren't locked away. Well, the problem is money is very rarely viewed as irreparable because if the trustee takes, money from the trust, in theory, they can just be forced to pay it back. And so money tends not to be irreparable. Things that are irreparable is if some harm's going to happen to a house, for example, because houses are unique. Real property is unique. Every parcel of real property is a little different. You can't just necessarily replace it with another house. And so, for example, if the trustee isn't paying the mortgage on a house and it's about to be lost to foreclosure for that reason, that could be an irreparable harm where you might be able to freeze some money, force the trustee to pay that mortgage, or even get the trustee suspended in that instance. So you have to think about what your argument's going to be if you want to bring a temporary restraining order and preliminary injunction. And you should just know going into it that it's not a sure thing. So you might get a court to grant it. You might get a judge to be convinced by your arguments, but don't count on it. There's no guarantees when it comes to those types of motions. So those are the two ways to lock down assets: the lis pendens for real property, the temporary restraining order, preliminary injunction for liquid assets. But that aspect of it is a little risky. You're never sure if you're going to get it or not. But if you want to try, if you want to lock down assets, that's what you have to do. Albertson and Davidson is here to help you fight for your inheritance. Check out aldavlaw.com for our complete library of helpful legal videos and articles from your favorite California trust and will litigation law firm, Albertson and Davidson, LLP.